The Ides of March are coming for the former president. Earlier today, Chief Judge Beryl Howell of the U.S. District Court in D.C. partially granted a request from U.S. prosecutors to force Trump lawyer Evan Corcoran to testify before a grand jury. Corcoran's testimony is related to the former president's possession of classified documents after leaving office. The request was made when prosecutors sought a crime fraud exception to his testimony. A lawyer can be forced to divulge private conversations with a client if the client is seeking advice in furtherance of a crime. This is an unusual move, but it suggests that Jack Smith's prosecutors provided significant evidence that Trump did in fact do that. Corcoran, who has already appeared before the grand jury, had previously testified to federal officials that Trump had returned all classified materials after they searched Mar-a-Lago, looking for documents that they had sought to recover for more than a year, a claim that was proven to be false. The Washington Post is reporting that Trump's legal team, the ones who have yet to allegedly commit a crime on his behest, are expected to ask incoming Chief U.S. District Judge James Boasberg, who succeeds the term-limited Howell as of midnight Saturday, to stay the order while they appeal. Joining me now is Jill Wine-Banks, who served as an assistant Watergate special prosecutor. She's the co-host of the Sisters-in-Law and iGen podcasts. And Jill, I do want to ask you to, it's great to see you. I want to ask you to comment on that. The fact that this lawyer, Mr. Corcoran, they have seemed to breach the attorney-client privilege to get him to testify. What do you think the significance of that is when it comes to the Jack Smith investigation?
It's important. First of all, there are a couple of things that he could be a witness to. One is a phone call that he had with Trump, and the other is instructions he gave to Christina Bobb to sign an affidavit that said there had been a diligent search and that all of the documents had been turned over. And she actually cleverly added some language to that saying, based on information that I have been given, because she didn't do the search. Corcoran did the search. So he could be responsible for a deliberate falsification of information, and that could get him into criminal trouble himself, not just in helping his client. And he would be the second lawyer on the Trump team who has had this happen. Eastman had the same thing, where the judge concluded that he and Trump had probably, more likely than not, committed a crime together. And that's one of the only ways that you can force a lawyer to give up the confidential information provided. It is something that every lawyer knows and that every client should know. So there's no big deal, and Donald Trump's defense claiming that this is a terrible thing is just nonsense.
I want to actually play. No, you know what? Let me play this one. I want to, because Trump is facing like all of these sort of multiple potential cases that are all kind of building and brewing at the same time. But the one that appears ready to sort of bloom first is this New York case about the payment to Stormy Daniels. And I want to play this. This is from June 25, 1973. You will remember this clip. This is John Dean testifying before Congress about what he told then President Richard Nixon.
I told him that I thought he should know that I was also involved in the post-June 17th activities regarding the Watergate. I briefly described to him why I thought I had legal problems and that I had been a conduit for many of the decisions that were made and therefore could be involved in an obstruction of justice. He would not accept my analysis and did not want me to get into it in any detail other than what I have just related. He reassured me not to worry, that I had no legal problems.
And he later went on, John Dean, to plead guilty for aspiring to obstruct justice in the cover-up and served a sentence, went to prison. He got 1 to 4 years. Yet he was would have been the chief witness had Richard Nixon been prosecuted. So what do you make of this attempt to say that Michael Cohen, who got a jail sentence for helping Donald Trump do this cover-up, you know, it seems odd to say that he wouldn't be a good key witness because John Dean would have been the key witness.
That's a great question, Joy. And it is absolutely true that in most white-collar crimes or mob crimes, the people who testify against the defendant are co-conspirators. It's not a bank robbery where you happen to be a patron in the bank who witnesses someone pull out a gun and say, give me your money. That isn't what kind of witnesses you have. You only have witnesses who know because they participated in the crime.
Right.
And no one was more credible than John Dean. He made no mistakes in the facts. And frankly, no one has questioned Cohen's accuracy in the things that he has said. They are attacking him for having been convicted of a lie. And your interview with his lawyer, Lonnie Davis, clearly shows how they are defending him against those kind of accusations. Right now, who looks more credible to you? John Dean, Cohen, or Donald Trump? I will tell you for sure the loser is Donald Trump.
Yeah. And the third thing is, and Melissa Murray, the great Melissa Murray, making attorneys get attorneys. It's like, these are all attorneys we're talking about on both sides of these accusations. Another attorney, and his name is Joe Tacopina, who has been on the attack against Michael Cohen. But here's a challenge for him representing Trump. He previously talked to Stormy Daniels, or stage name Stormy Daniels, about representing her. NYU law professor Ryan Goodman points that out, and that there is, New York State has ethics rules that say it would be difficult to see how he can represent Trump should there be a trial after he has attacked Stormy Daniels and sort of tried to sort of undercut her credibility. But he talked about potentially representing her. What do you make of all of that?
Well, I mean, anybody who saw his interview by Ari Melber knows, how can I say this nicely, that he's a clown, that he's a joke. Grabbing for the evidence I've never seen anything like that. Saying it's not a lie because it wasn't under oath. No, perjury is under oath. Lies are lies. If I tell you a lie, it's a lie. It doesn't have to be under oath. So his character and his ethics are clearly at issue here. And I think that if you have represented someone on the other side, you cannot represent the other person. You just can't. This is, it reminds me of advice I got early on in my career as a defense lawyer, which was sometimes the law is on your side, you argue the law. Sometimes it's the facts, you argue the facts. And sometimes both are against you, you pound the table. That was it. He was pounding the table.
Well, real quick, what's your pin before I let you go?
I'm actually wearing two because it's it's St. Patrick's Day, and in Chicago, that's a big deal. And because we're talking about individual number one in the indictment Cohen, I'm wearing a thing that says #1.
When I tell you Jill Wine-Banks never misses with these pins, thank you so much, Jill, my friend. Appreciate you. Thank you. Have a great, happy St. Patrick's Day.